The first appeal on this afternoon's calendar is Appeal Number 121 and 122, Desrosiers versus Ellis, Vasquez versus National Securities. Counsel?
Good afternoon, and may it please the Court. My name is Daniel Bezzetta on behalf of National Securities Corporation. May I respectfully request 1 minute for rebuttal?
You may, sir.
Thank you, Your Honor. Your Honors, by its explicit and plain terms, CPLR 908 applies only to class actions. Reinforcing that fact is the requirement that notice be distributed to all members of the class. Only class actions have members of the class. This case was never a class action. It was never certified as such under CPLR.
Avena has been the rule in the state for over 35 years. And in essence, you're asking us not to overturn our decision, but the First Department decision and the effective jurisprudence of the state for 35 years. Do you agree with that principle?
I do, Your Honor.
Let me just follow that up because that's self-evident. I think we all agree with that. But what is there in the legislative inaction that would make us think that if they wanted to change, they would have changed it? They've done nothing for all this time, and you know, they know about the rule. They've been familiar with it, and if they haven't changed it, why should we change it?
Two things to that, Your Honor. First, at least one commentator has noted that the Avena decision in the 35 years since it's been enacted.
That was McLaughlin, but the Vincent commentaries were a little bit different, I thought, and perhaps a little more balanced.
Respectfully, what I was referring to is the commentary that, I believe in 2015, that Avena has all but been ignored since it was enacted in 1982. It's an obscure decision, not well known. Courts have followed it in the breach. Some courts have applied it, others have not. And I would
counted a number of trial courts that have relied on it.
Your Honor, that's right. There are a number of trial courts, but I would submit that there are an equal number, if not more, trial courts that have either ignored it, have not applied it, and frankly, Your Honor—
But it's always been the rule of the First Department, right?
It has, since
First Department has always followed its own precedent, correct?
There was one case, the Astill case, Your Honor, where the lower court cited to 908 for requiring notice, but when it got to the First Department didn't even cite its own precedent in Avena. It didn't even discuss 908. I would submit that the Avena decision is not well-reasoned. It never looked at the legislative history to Rule 908. And this
So
court—
if we agree with you, does that incentivize or disincentivize abuse?
I don't think abuse becomes an issue when, as in this case, you have the named plaintiff settling individually on his or her behalf with no preclusive effect, no res judicata effect on any members of the putative class, to the extent any exist. They could have brought their own lawsuit if they wanted to, notwithstanding the resolution with Vasquez, notwithstanding the resolution with Avena. And therein, frankly, lies one of the issues with the Avena court, which is they did not consider what is the impact to the unnamed class members. They assumed that when a named class representative settles, that there is personal aggrandizement.
If I may, a moment ago you started to say that the Avena court did not look at the legislative history. But why would we even do that, and why would they do that if the plain language, as you were just arguing a moment ago, is so unambiguously clear?
Correct, Your Honor. And this court—
So to me, there's a little tension there.
No, I thank you, Your Honor. This court has held that the first thing you look at is the language of the statute. Where it's clear and unambiguous, you can rely on that language. Yeah. But you should also consider, and can also consider, the legislative history to see if the language somehow undermines the intent of the legislature. Here, there is not one word penned in the legislative history that suggests that 908 or any article of Article 9 was intended to apply to cases that were not certified as class actions.
What, what, did, what, 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 what was the understanding of the federal rule, Rule 23, before the amendment?
The amendment that occurred in 2003 to clarify that under the federal practice, notice is only for certified cases, there was,
But doesn't that mean that before that, notice was required regardless of certification? Isn't that what the cure was, the amendment was intended to do?
there was a clarification because there were some courts, not all courts, some courts looked at that prior version of 23E and applied it to putative cases, beginning with the
But
Philadelphia.
wasn't it the majority of circuits who had applied it?
I don't think it's the majority of circuits. In fact, I think that there's an equal balance. If you look back at the Shelton case with the First Circuit, the Fourth Circuit, that case goes through.
But even if you're correct, then aren't you merely arguing that the situation in the federal courts is the same as the situation post-Avena in the state courts? And if Congress felt it was necessary to amend to clarify, or the rule, excuse me, had to be amended to clarify, then wouldn't we expect that the state legislature would have to do the same? Or you'd need the same clarification for 908?
I see that my time is up. May I answer the question?
Yes.
Your Honors, I don't think anything can be read into the legislative inaction by the New York legislature. Again, Avena, not a well-recognized law, all but forgotten. Legislative priorities being what they are, I think it is within the province of this court, Your Honor, to interpret 908 according to its plain meaning, and especially since the legislative history has never indicated that it applies to anything but certified class
Can
actions.
anything be read into the use of the word maintain in section 902?
I don't think so, Your Honor. When you take a step back and you look at Article 9 and why it was created, it was enacted in 1975 to provide a procedure to manage class actions. 901 and 902 are simply the gateway for a case to become a class action. All of the rules that follow that are all rules that are...
Or to be maintained? Perhaps it's a class action upon the moment that it's filed as a class action, and in order to maintain it to its logical end, if you're going to run out the litigation.
You would expect that to be in the legislative history, and it's not. And I again repeat that the whole purpose, the text, the purpose, the structure of Article 9 was intended for the management of class actions, and everything that follows Rule 902 are all geared to the management of what is a class action, notice in a class action, attorney's fees in a class action. And the penultimate section is 908, which says that a class action cannot be settled without notice to all members of the class.
Chief, I have one question, if I might.
Yes, please.
Counsel, do you know as a practical matter under 904, which requires notice, whether the notice is sent out on filing or sent out on certification?
On certification, Your Honor, there is no case that we have found where notice is sent out on filing. The 904B notice that Your Honor is referring to is notice that is issued with the permission of the court once the court certifies the case as a class action.
Chief Judge, may I ask one question? So to follow up on that, on a basic question, in this case, who would get notice? How would you know who would get notice?
That's a very good question, Your Honor, and frankly, I don't have the answer to that because this case was never certified. A 903 order was never issued identifying the members of the class. Therefore, it raises a very real practical question.
But we've had this rule on the books in the First Department, at least, Avena, saying you do this, so who gets notices under those cases?
No cases that we have found have actually explained that, Your Honor. It's a mystery. Who will get notice in a case that has never been certified?
How is the class defined?
Very broadly, Your Honor. On page 11 of the record, it says, persons who performed such trades, including but not limited to. This is in paragraph 10 of the record. Who is that in this case that was filed in 2014 with a 6-year statute of limitations dating back to 2008? Who has common claims? Who is typical? Who has typical claims? Are there enough? The numerosity requirement, which is a requirement to be a class action. We don't know if there's 1, 100, or more, because the 902, 901 analysis was never done in this case, Your Honors. Therefore, it raises the legitimate practical question, who gets notice? And no court has resolved that. The Avena court didn't, and the court below did not resolve it. And you run the risk, Your Honors, of sending out notice to a broad group of potential class members, thereby prejudicing the defendant, or perhaps underestimating and limiting the notice which potentially could prejudice putative class members out there. It is really, Your Honors, a question that has not been resolved, and another reason why the Avena decision was not well-reasoned and should not be the law in the First
Thank you,
Department.
counsel. Counsel?
Good afternoon. May it please the court, I'm Frank Henry, and I represent Perry Ellis International. Thank you for letting me appear in front of your court. I'm from Florida. So when this case was filed, we made the decision early on, after having been served with the complaint, to serve an offer of compromise to the case. We did not believe in the merits of the case, and we served an offer of compromise in order to limit our costs in litigation. It was accepted within the time limit required under the rule, and we waited. We paused to move to dismiss the case because the plaintiff had accepted the offer. We paused until the expiration of the 60-day period within which the
What should and could the plaintiff have done if the plaintiffs, plural here, wanted to pursue this further as a class action, to let other people know that this was happening, and to have a broader impact?
The plaintiff should have filed a motion to certify the case as a class action under Section 902. We would have had a hearing. We would have determined what the appropriate class was. And under Section 904, there would have been notices that would have been sent out.
Was there anything in your settlement agreement that prevented counsel for the plaintiff from going and looking for other plaintiffs?
No. No, we didn't have a settlement agreement. We served a pure offer of compromise to enter one judgment against our client, exclusive of costs, and the plaintiff thankfully accepted it. The plaintiff satisfied with the result. We were satisfied with that result. We waited for the 60 days to expire, and when we moved the court to dismiss the case, for the first time, the plaintiff raised this issue of class notice. The plaintiff stipulated to the dismissal of our case. There was no issue in front of the trial court as to whether the case should be dismissed. The plaintiff's only argument was that because under Section 908, under its, as you just heard argument on, under the language of Section 908, because this was styled as a class action, because it was pleaded as a class action, that it was therefore a class action, and therefore the court was obligated to send out notices to the class.
I'm curious if you have any thoughts about the problem that came up at the end of the last argument, which is why is it impractical for the court to sort of fashion who's going to get notice later on? I know that's not necessarily how you would do it if you were, trying to certify the class on the plaintiff's motion, but fine. You offered the compromise, you picked them off, that's fine. Now have the hearing and figure out who gets the notice and fashion the notice as part of, because any notice always has to be approved by the court before it's sent. So why can't the court do it then?
So there are a number of parts of that process that are unpredictable in my view. If you affirm the decision of the lower court here, we're going to go back to the trial court, and presumably we're going to take discovery, and they're going to take discovery as to who the members of this class are. And then there's going to be a hearing in front of the trial judge as to the appropriateness, numerosity, typicality, adequate representation.
But the reality is, for your action anyway, it's going to be whoever was an intern in a certain time period. Really not that hard. It's a matter of searching your records.
On its face,
I don't know what discovery you're going to need from the plaintiff. It's really all going to be in your control.
On its face, you're correct, but the reality is that this is a claim for unpaid wages, depending upon the argument that those interns were employees. And their status as employees is dependent upon their individual job duties and responsibilities. So let's say there are 300 people in this class. Well, whether or not any one of those 300 people are actually employees of my
Yeah, but that's a
client.
merits argument, right? That's a merits argument. That has nothing to do with just giving them notice that the complaint is no longer active. I mean, that's a merits argument about, that could have been true even if it was certified as a class, right? because you might have very much challenged certain persons as not employees down the road.
It goes to the issue of typicality, I think, and whether the claims of the representative plaintiff are typical of the group. And my argument would be at that hearing that they aren't typical of the group.
Does it go to predominance as well?
I'm sorry?
Does it go to predominance as well?
It does, because we don't know whether, the reality is we would have to go back and have this hearing in every class action that's pleaded
So do you
before
know
the
of
trial court.
any circumstance where a hearing like that has actually occurred to provide notice in a case that had been settled?
Not to my knowledge, no.
So this is your hypothesis of what might happen?
Yeah, that's exactly right. I have no expectation of what we're going to do when we
But
get back to the
your
trial
whole
court.
argument is, you're just going to make us advise people who really would never have fit under the class, but the alternative that you present is that nobody gets advised. So I'm not really understanding the logic of that approach.
The problem with...
It might be less costly, I get that argument, but otherwise I don't see, from the fairness perspective or even from a logic perspective, why your rule works.
Your Honor, respectfully, there has to be some reason for this Rule 908. And the only reason that I can see for the rule, if I can continue, I see that my time's up. The only reason that I can see for the rule is because in an ordinary case where the plaintiff had timely moved for class certification, the court would have sent notices out to all members of the class, and those notices would have said, you're a member of our class. Your rights could be prejudiced as a result of what's going on in this court proceeding, and therefore, you should pay attention. It would say something to that effect. In this case, that never happened, and so the notice that we'll be sending out, if you send us back to the trial court with that directive, is that this case that you've never heard of because no notice was ever sent out, and a case that you'll never be a part of because you can't join it, it's been dismissed, and a case that's never going to be certified as a class action because under O'Hara, the 60-day rule has expired. We're telling you the name and address for the attorneys for the plaintiff.
So what you're
That's the
saying
only
is
substance.
that this is no different from a procedural posture than if the plaintiff had only sued on his own behalf.
That's exactly right, Your Honor.
And then other people under similar circumstances would either come to the decision that they had a cause of action on their own, or they wouldn't.
But yes, that's true, but the notice that the court will be sending out, the only useful information on it will be the name and address of the plaintiff's attorneys. And I was talking before we came into this argument, if I was a plaintiff's attorney...
See, I would
this
disagree with
rule-
you. The useful information may be that someone may not even be aware that they would have an action, and now they would be aware that they have an action. And that's the fundamental policy distinction between the notice and between giving notice and not giving notice. Somebody's aware now that they may have an action and justifiably object to it, but still there's a basis for it other than providing the attorney's name.
The notice that was prepared by the plaintiffs in this case expressly disavows any substance as to whether there's a claim to be had in the case. In fact, it says, we're not telling you you do have a claim. In an ordinary case where the procedures...
No, they're
have
just
been-
telling every intern who works that
Telling every intern to call.
there's a possible class action out there.
Exactly.
So, yeah.
Thank you,
okay.
counsel.
Thank you, Your
Counsel?
Honor.
Good afternoon, may it please the court. I'm LaDonna Lusher.
Counsel, could you simply put out ads saying, I see them on TV all the time, saying, if you worked for Perry Ellis, or, you may have, and during such and such a period of time, you may have, you may have an action against them, call 1-800, whatever.
Yes, absolutely, we could.
Okay, so I'm struggling to understand why the particular posture of these cases is any different from any case where a person sues on his or her own behalf. The only difference being that they use the words "and others similarly situated," but nothing further happened. Nobody was ever notified that this action was brought or pending, or they might have any rights or anything. And then at this early stage, it's settled. And the plaintiff says, I'm happy, I don't need to pursue this class action, thank you very much. Why, what purpose is being served to this unknown putative class to send them notice at this point in time that this action was settled?
It's actually a dual purpose, and the court in Avena, I think, does a wonderful explanation of explaining why. The first is that you're notifying potential class members that their fiduciary that had an obligation to them has now settled his or her claim.
Yeah, but when does that's one of the problems, questions I have about Avena, is this fiduciary duty. When does that arises the moment somebody files a lawsuit saying, myself and others similarly situated, all of a sudden there's this class of people that they have a fiduciary duty to?
Absolutely. As soon as that class action is
Until the
filed.
class is certified, you don't actually have a determination by the court that counsel is adequate, do you?
Well, you don't, that's true. I mean, there's a point in time after some class certification discovery is done, and then the court rules whether or not the elements of Article 9 have been met for it to proceed or be maintained as a class action. But even as soon as it's filed, you have a named plaintiff who is now representing every other potential member of that class, and they have a duty.
That's the question, right, is whether they're representing them or whether they're asking for permission to represent them.
Absolutely, and they do. And it's the whole purpose behind why Article 9 was enacted and why particularly the part about Section 902, talking about how you're supposed to decide early on whether or not a class action should be maintained as a class action before getting to the merits of the actual decision of a case.
Suppose there were no settlement and the court dismissed the action. Is notice required?
Yes, it would be, in most cases. There are decisions that are out there that actually have been decided from some trial courts and also from some of the federal courts that have said if there was an involuntary dismissal on the merits, that perhaps notice wasn't needed. But in the majority of cases, if you have a situation, particularly as in these cases, where you have a settlement where a named plaintiff has now settled his or her claim, and the case is not going to continue, that the court has a duty to send out notice to the beneficiaries that have had an interest in the action since it was filed and whose statute of limitations are now ticking. The First Department cited American Pipe in one of its decisions.
But if this action had never been brought, their statute of limitations would be ticking. And it's stayed during the pendency of the action, but if they never knew that an action had been started in the first place, then they still have the same responsibility to do something within the statute of limitations. So again, I don't see how they're prejudiced by this particular situation.
It's a very good point, and it was actually discussed by the court in Avena, and it's also been discussed by other federal courts who said that whether or not these people know that they actually had a cause of action doesn't matter. What matters is that there was a fiduciary who has now settled his or her claim, and that a notice should go out to make sure that there's no collusion in that settlement.
But if we were not to agree with the fiduciary duty aspect of Avena, then where does that leave us?
Then it also goes to the second part of the purpose behind 908, and that's to inform individuals that their statute of limitations is now expiring.
But when I have a cause of action for something, whatever it may be, negligence or whatever, do I have somebody to alert me? Do the courts somehow alert me that this is my statute of limitations and it may be running? I don't understand how the fact that an individual plaintiff brings a lawsuit somehow changes my responsibility to file my claim. Again, assuming that I've never been notified of any of this, and I'm just going along my merry way.
Sure, absolutely. And part of the reason that Article 9 was enacted was to help streamline class actions so that individuals could rely on other individuals to bring an action, and that you didn't have all kinds of different plaintiffs running to the courthouse to file their own separate actions. And it goes towards streamlining that so that you do have one individual that brings the action on behalf of the rest of the class.
And tolls
And
the
tolls
statute of limitations for those individuals.
Exactly, so that those
And that's part of the purpose of sending out the notice, so that they know that toll is being lifted.
Absolutely, and they can sit
But how
back.
do they know the toll was in place?
Well, some do and some don't, but the whole justification behind it is so that they can be notified once the action has been dismissed, that they now have a claim that could be expiring.
Would it
And
be
it's-
more effective then to say that anybody commencing an action in which they purport to be doing it on behalf of a class must, at the time that they file and serve their summons, they make an application for determination from the court as to whether whether to certify it as a class. Wouldn't that be a more effective way of doing this?
From the very beginning? I mean, from the way that class actions used to be brought was that you had all kinds of different people filing actions and intervening to join. And there is language in Article 9 that talks about sending out notice at the commencement of a class action. But this particular section of 908 goes directly to the point of these two cases, and that's where you have an individual who's settled. And you have to protect the class action process and its integrity by notifying other individuals so that they have the opportunity to object to that settlement, to be notified about
How is it a
it.
class action if no class has been identified, nobody's been notified? It just, to me, it seems like it's a, it's an attempt to get a class action.
It becomes a class action as soon as it's filed, and that was recognized by the Supreme Court in American Pipe. And they discussed how the statute of limitations was told the moment that that class action is filed, and it's on behalf of all potential members of the class.
Can I turn you to one of the potential effects? Let's say this court reversed, and we said that we wouldn't apply the notice provisions. Would this have any effect on the court's approval process, say, of termination of class or in any other way, if we reversed? Would the court even need to approve the termination of a purported class?
I believe that it would.
Would it?
Yes. I believe that, in Avena,
This is
again,
if we reversed Avena.
even if you look at the language of the statute, the language is mandatory. The language says that a class action shall not be dismissed, discontinued, or compromised without approval of the court. The second sentence says that notice of that proposed dismissal, discontinuance, or compromise shall be given to all members of the class in such a manner as the court directs. And going back to a question that was earlier about Article 9 and whether or not class action means putative class action or certified class action, there are several provisions in the article that say the words class action. And for instance, Section 902 that I was just discussing refers to a class action, but we know it hasn't been certified yet because that's the rule that says you have to be able to apply for certification within 60 days. But it refers to applying for that certification of the class action. There are other provisions of Article 9 that say maintaining as a class action, and those are Articles 909 when you're talking about attorney's fees, where the individual attorneys apply for their fees at the end of the case, and that's after the class action has been maintained. The same is in Section 905 as well. So this language for class action appears all over the statute, and it most certainly applies to putative class actions as well as certified class actions. And if you look at the justifications...
What about Hara's language? Doesn't that sort of indicate that it's not a class action until the plaintiff takes the steps necessary?
The O'Hare decision was an interesting decision because what happened is that there was a decision that was made on the merits of the named plaintiff's claims. And the named plaintiff didn't move for class certification, but the trial court, sua sponte, certified the class. But the court's decision really emphasized the fact that a meritorious decision had been made on that plaintiff's claims, and you can't then certify a class because at that point you've now opened the door to a judgment that has been given in favor to a plaintiff, and now you're going to decide who that judgment affects. And that's another reason that you have to decide class certification status early in a case so that it's done before the merits are ruled upon. Then, at that point, you can have a decision on a merits that affects the class, but you have to define that class first before that meritorious decision is made.
If I can just circle back to something else we were saying about streamlining the class action process and the integrity of class action. So it's a slightly different comment that I'm going to make, and I want you to address it. So as I think I'm understanding in part your advocacy of this rule is that from the plaintiff's perspective, what society gets from this is the possibility that someone's going to be notified and they may pursue either individually their own rights or a class action on the same claims or similar claims. But the employer's rule or the defendant's rule is one that seeks to undermine that effort to the extent that people aren't on notice. Right? Is that sort of at the end of the day really what this boils down to? The notice provides the possibility that, again, is reflecting a societal interest that if indeed there is a harm, those who have been harmed now know and they can choose to take action individually or as a class.
Absolutely, or they can choose to take no action at all, which often happens.
Correct.
And that's the whole point behind the statute. It's a twofold purpose. It serves to show that there was no collusion so that all the other beneficiaries can be on notice and decide whether or not they want to object to the settlement or intervene. And then it also shows and tells them that their statute of limitations is now ticking.
Yes.
And these things apply whether or not a class action is certified or whether it's not certified. You have putative class members who need to be on notice of whether or not their fiduciary has now settled a claim that they thought that they could stand by and watch be brought on their
But
behalf.
what about the issue of how to define the class if it hasn't been certified beforehand?
Honestly, I'm sorry, excuse me. It's honestly very easy. My firm prosecutes class actions every day, and there are notices that go out all the time.
And how many times does the certified class match the definition in the complaint in your experience?
I'm going to say most of the time. It does. The majority of the time, it does match the definition in the complaint. But again, it's practically speaking, it's something that's really worked out very easily between plaintiffs' attorneys and defense attorneys and that a court oversees. It's really very practically done. And it's also, there's a corollary to when you think about it under the Fair Labor Standards Act for 216B actions. In those cases, you have a notice that goes out very early on to similarly situated plaintiffs that there's been no determination as to whether they're actually similarly situated. But a notice goes out to a group that's been identified. A little bit of evidence has been put forth that that may be true. And a notice goes out to tell them that their statute of limitations is ticking and they need to file a claim form in order to stop that so that they can be part of that action. That's nothing different than a notice going out here to class members under Article 9, where they were notified that their statute of limitations could be expiring. If they need to do something or want to do something, they have that opportunity. And in these two particular cases, you will have a lot of individuals who now will not be able to bring claims for unpaid wages if this court were to decide that notice should not issue, because they won't be notified. I know my time is up, but I just wanted to make that point that you have individuals, we filed this class action in 2014 in one of the cases. You have individuals who have unpaid wage claims from 2008 to 2011 who will no longer be allowed to bring their claim because their claim will have been expired and they won't have been notified. Under Perry Ellis,
This particular plaintiff had never sought to recover for himself. They never would have known either, right?
perhaps, but perhaps they did know. I mean, just because it's not a highly publicized case on TV doesn't mean that the named plaintiff didn't say something to some certain people, doesn't mean that other people weren't aware of an action. Just because other people haven't come forward doesn't mean that they don't know. And my firm gets calls from people all the time who don't necessarily want to step forward and put themselves out there.
So assuming that's true, those people who hear that somebody else filed a lawsuit figure they can just sit back and wait till they hear something?
Absolutely they can, and that's been one of the justifications for having notice in a class action. And it's also one of the justifications for, at the point that a class is certified when a notice goes out, people have an opportunity to exclude themselves. And if they don't, then they're part of that class. And they have that opportunity at that point, but they also have to be notified that that's a gamble that they take if they don't exclude themselves. But it's a very important, notification couldn't be more important here, where in the other case where you have interns who only had unpaid wage claims for approximately 3 months. Those individuals, if they aren't notified, they will also lose their opportunity to bring a claim. And that's one of the most important and compelling reasons behind this statute.
And
Thank
if
you,
they're good
Councilman.
claims, why can't you find them, these people?
If they're
Can't you
good-
ask your client, do you have any friends who are interns? Can I contact them? I've got a good claim here.
Well, practically speaking, there are a lot of ethics rules for plaintiffs' attorneys about how, whether or not
You already have
what
a
is
fiduciary
proper.
obligation to them, you told me.
I'm sorry?
You already have a fiduciary obligation to them, you told me.
We
Seems
do
to me
have
if you have a fiduciary obligation to these unnamed people, you can't have an ethical violation from trying to represent them.
Well, I think that Judge Kahn commented on that in the Empire Blue Cross Blue Shield case, where he said that there was nothing stopping from the plaintiff's attorneys in that case from putting out an advertisement. And that was alluded to earlier. And that's true. We can put out advertisements ethically and properly. However, it's not the same as a court-authorized notice that has been approved by a court, and it also may not go to the same people. I mean, practically speaking, counsel brought up that who would you even notice in the notice to? Well, there's been cases where courts have ordered you give the names and addresses. It's the same that happens in any class action. You give the names and the addresses of the individuals that are members of the class or the putative members of the class, and you send out notice to them. Perhaps an
The kind
attorney
of general newspaper notice that you're talking about anyway is very much frowned upon It's not geared to give actual notice, which is the point here. And you have to have a judge order that when that is the last possible recourse.
So do we
Absolutely.
know why the federal rules were amended to say that notice wasn't required under these circumstances unless the class had already been certified? Did the federal government not consider the arguments that you're making here?
I think that they did. In the courts, there was a real split amongst the courts at that time. And it was interesting because
So they could have gone either way to clarify what the rule, what should be, right?
They could have. However, I think that it's important to consider the fact that the federal legislature took it upon themselves because the courts were divided to amend the rule and to decide that it was only going to apply to certified class actions.
But isn't that what we're doing here? I mean, they did that because the Supreme Court hadn't ruled on it. So we now have the opportunity to rule on it, unlike the federal situation where they had this split, nothing was happening. And so the Congress acted, they acted to change the rule. So I don't really understand that argument that we should wait for the legislature because we've never considered this and we can clarify it. We don't need to do that.
You're
Isn't
absolutely.
it different here? Because you've already had Congress amend, you've already had the amendment of the federal rule and the state hasn't acted.
Well, you're absolutely
Well, this
right.
court hasn't acted.
And there's no split here.
You're absolutely right. And this court can do whatever it decides.
I'm not talking about among the the 7 of us. I'm talking about there's no split in the departments.
It's true. This court can do whatever it decides. But, I would emphasize that there's a part in our brief that we discuss about how this precedent has been followed, at least by the lower courts, for 30 years. And for this court to overturn Avena at this point,
But aren't we making the First Department the Court of Appeals there? I mean, we've never ruled on it, so if people have been following a First Department case, I mean, they can do that. Other departments aren't bound by it. So this is our opportunity to say what the rule is and to interpret 908. So the fact that there's been a First Department rule out there for 30 years shouldn't really be the end game for the Court of Appeals, right?
agreed, but it's a very persuasive decision, and the reasoning
People can
behind it is...
disagree on its persuasiveness.
Well, perhaps, but the reasoning
It may
behind
have
it is...
persuaded the state legislature.
Exactly. I mean, the thing is that I think that this court can look to the fact that the legislature has had the opportunity, and just as recently as March 2016, legislation was presented to
Although
at least
haven't
in
we
the
said in
Assembly.
other contexts it's very hard to read the motives of the legislature when they don't act?
That's true, but they did not change the rule. They haven't changed the rule to this day, and the majority view has been that this statute applies to class actions whether they've been certified or whether they haven't been certified. And if the legislature wanted to act, it could have, and it hasn't yet.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. I'd like to briefly address the issue of the purpose of notice. We've heard that notice the purpose of it is to advise the putative class about the tolling or the ticking of the statute of limitations or letting them know that the toll is in place. Respectfully, I think that is a red herring. Notice is imperfect because in a whole slew of cases, notice is never given, or if it is given, it's given too late. For instance, consider the American Pipe case, which is the case that from which this notice issue derives. In that case, after the case, the court decided that the case was not a class action. The putative class only had 11 days within which to file their claim, or their claim would have been time barred. Notice would not have been issued within 11 days. So this notion that you need to give notice to advise people of their rights, notice wouldn't have come in that case. Notice doesn't come in cases where class certification is denied. Notice doesn't come in cases where motions to dismiss are granted. So there are a whole slew of cases where you do not get notice. Instead of relying on notice to advise
Isn't that
people
where you
of their
lost
rights.
as opposed to where you settled?
I'm sorry, Your
Isn't that
Honor.
where you lose as opposed to where you settled? Wouldn't that make a difference?
I'm sorry, I didn't hear you.
Isn't that where you lose instead of where you settled? When you settled, you got something for it. That means, I suppose, that the claim has some value. That's why people want notice.
But again, at that point, Your Honors, we need to go back to the plain language of the statute, which says what was settled, not a class action, but an individual claim was settled.
That was brought in the context of a class action statute.
Right, but the class was never certified under 901, 902, and there are no
Which
preclusive...
goes once again to the argument of that the class action can't be used for an individual's benefit, and to create the economic parity that's the underlying policy principle behind a class action lawsuit, you want to make sure that people that have similar claims be notified.
But let's put the onus on the people that have those claims to be aware of their statute of limitations and to bring those claims when they have them, rather than rely on notice, which is imperfect and may never come. And frankly, Your Honors, I think what the Avena Court also does, talking about societal interests, it discourages settlements, right? If defendants would have to have notice go out notwithstanding an individual settlement, I would suggest that perhaps defendants would not settle cases because effectively every
That just
case...
feeds into the argument that the class action can't be exploited for an individual. It has to benefit the class. And if it doesn't benefit the class, then it seems to inherently suggest that it's benefiting just the individual, and it was brought solely for that purpose. In other words, it was kind of a red herring.
It could only benefit the class upon certification, which didn't occur in this case. And here we have a plaintiff, Vasquez, who decided to settle the case on his own to benefit himself, never even sought approval under 908, and belatedly sought notice. But he did decide to settle the case for his own benefit rather than from the class. And, Your Honors, I submit that in a case where there is a settlement pre-certification, where there is no impact on the putative class members, 908 does not require notice.
Counsel? Thank you, sir.
Thank you, Your Honors.
Thank you, Your Honor. There's been no adjudication of liability in either of these cases. There was a settlement, a tender, and the idea that we'll be sending out notices to members of a class notifying them of their rights is misleading because we don't know whether the plaintiff had a good claim, much less anybody in the class. I mean, what I hear the plaintiff advocating is a system where the court is sanctioning an educational experience for the public based upon a lawsuit that was filed.
No, not for the public.
Well,
For
these
the
are
public, potential potential plaintiffs who may have been injured and who may have a claim.
Imagine, Your Honor, if the plaintiff in this case, instead of identifying interns as the class, had identified as all non-exempt Perry Ellis employees, such that when we picked off the plaintiff in the case, we guaranteed that the court was going to send notice to every single non-exempt employee, which is almost everybody at Perry Ellis International. Well, that's the court sending a notice to those people saying, you have rights under New York law. You have rights under the Fair Labor. You may have rights under the Fair Labor Standards Act. We discussed the Fair Labor Standards Act and the federal procedure for sending out notices in those cases. And before those notices go out, there's a hearing. And there's a determination as to what the notice is going to say. And it's all before an adjudication of liability. It's all before there's a trial. It's all before something occurs in the case. There's never a circumstance in an FLSA case where there's been a trial or been a settlement or been any kind of adjudication of liability and the notice goes out after the fact. In fact, that's what the O'Hara case mandated against. It said that you can't have notices going out to class members after the liability's already been established, because then you've got a group of people that are coattailing on a plaintiff that took the risk, filed a lawsuit, and that's what's being advocated.
But in the settlement, is the employer agreeing, or is the defendant agreeing that they're liable, that indeed they did violate the law?
No. We've never...
I'm not understanding your analogy, I'm sorry.
Well, the plaintiff was saying that in FLSA cases that these notices are sent out routinely to class members, and that's true. The Fair Labor Standards Act, Section 216, allows notices to be sent to similarly situated people, but there's always a hearing before those notices are sent out as to who the notices are going to go to, and it's always before a finding of liability. So that these people have either opted into the case or they're not in the case, but at the time there's a trial, we know who's involved. What the plaintiffs are talking about in this case is much different. The plaintiffs are talking about in any case where a class is alleged in the complaint, that the court sends out a notice to anybody that's broadly alleged in the complaint that they may have rights under the statute and that they should call the plaintiff's counsel to discuss them. And that's a very different thing.
Thank you, counsel.
Thank you, Your Honor.